very good evening to all of you friends and welcome to the mega mock analysis of BYJU'S Exam Prep. Guys, today we begin with the discussion of the legal reasoning section of the mega mock analysis. Okay, so there was a mega mock test that took place between 10th and 12th of June 2022. Today we are going to have an analysis of that particular mock test. So, what was this pattern of this All India Mega Mock Test? From the legal reasoning section, there were 40 questions and 8 passages. Every passage had 5 questions each. So, from the legal reasoning section, there were 40 marks, 40 questions, a +1 for every correct answer and a negative of 0.25 marks for every wrong answer. Now, in this particular section, that is the legal reasoning section, there were 8 passages. Okay, 8 passages containing 5 questions each and in a total of 40 questions. Now, let's see. Let's have an overview of the places or the laws from which these 8 passages came from. It came from section 21 of the Indian Contract Act, then it came from the void agreement, then wagering agreement, article 20 of the fundamental rights to the Indian Constitution, section 85 of the Indian Penal Code. Again, we had a passage on right to life, that is article 21 of the Constitution, and then we had a passage on the Keshwananda Bharati's case, and finally we also had a passage on the Citizenship Act, right? So these were the 8 passages from which questions came. So guys, I'm sure that you have sat for that entrance exam, for that particular mock test, and I'm sure that you know the passages well. So I'll just give you half a minute's time to go through the passage so that we can start solving these questions. Okay? So guys, let's begin. Please read the passage. Okay, so this was a passage which dealt with mistake of fact and mistake of law. The difference between mistake of fact and mistake of law was categorically mentioned in this particular passage. What are the exceptions to the rule and what is the rule all about, right? Okay, fantastic. So we have Akansha, we have Mosvi Malik, then we have Ayushi Patel, Akansha. Fantastic. A very good evening to all of you. Read the passage very carefully. Read the passage. So here is the passage that came in this particular mega mock test, right? Yeah, the final slide. The final slide is up on your screen. Okay, fantastic. I'm sure that you must have gone through this entire passage while you sat for this particular mock test. Now, let's go to question number 1. The first question. Brijesh is the owner of a cotton mill and each season of production necessitates cotton. As a result, he gets into a contract with a local cotton SHG to obtain raw cotton. he agreed to buy a specific amount of cotton based on his letter, which stated a price of rupees X instead of rupees Y, owing to a typographical error. Now, here we see some typographical error creeping out of a particular contract. Now the question is the agreement legally enforceable? And the correct answer is no, it is a mistake. The contract is void owing to a mistake because it's a mistake as to subject matter. The correct answer is option C. Option C is the right answer. Moving on to question number 2. Please read the question. Please read the question, guys. After Ram's first wife died, did not return from her journey, Ram and Eve had even living together for 3 years. As a result, they assumed they were legally married and reached an agreement to divorce. However, the man's first wife was later discovered to be alive. According to the law, a person cannot have 2 spouses at the same point in time. What will happen to the separation agreement between Ram and Eve? Remember one thing, mistake of law is not an excuse. So the correct answer is the agreement of separation between this man called Ram and Eve is void because they were not married at all in the first place. They were living together. Living together does not amount to getting married under the law. Is that clear? Have I made myself clear to all of you? Okay, so the correct answer is option B. Option B is the right answer. Okay, moving on to question number 3. Which of the following is the correct enunciation of the principle of the Indian Contract Act of 1872? And the correct answer is mistake of fact is an excuse, whereas mistake of law is not. Mistake of fact happens to be an excuse, whereas mistake of law is not. Mistake of law is not an excuse. So the correct answer is option B again. Okay, I'm sure that you guys are able to understand that. Okay, so if you're liking today's session, do press on the like button, guys. Question number 4. Nissan and Co. is an Indian company dealing in the manufacturing and sale of noodles. It agrees to sell 2 lakh packets of its product to a Chinese company which has a trans fat of 50% per packet. However, China has banned purchase of any product having more than 30% of trans fats in it. So there is a law. China has banned purchase of a product having more than 30% of trans fat in it. And here is this particular noodles which has 50%, right? Am I clear? So the correct answer is a contract valid? It is invalid. The contract is not valid. It is a violation of a law. So the correct answer is no, no, no. None of the above. Option D is the right answer. It is not voidable, it is void. It is void. So none of the above is the correct answer, dear friends. So this is how you have to solve these questions. Moving on to question number 5. Jitu is a first-year student at Delhi University. He travels by the DTDC for the first time in life and is unaware of the fact that unlike in his state where the conductor comes to your own place for giving you a ticket, you have to approach the conductor for the ticket. Meanwhile, A checking takes place by the flying squad of DTDC, finds Jitu guilty of traveling without a ticket. Now, can he plead ignorance? And the correct answer is no. It is a mistake of law. Am I clear? So the correct answer is option C. Option C is the right answer because it is a mistake of law. He did not knew that in the DTDC system in Delhi, the Delhi Road Transport Corporation has these buses where you have to go to the conductor and buy the ticket, right? Okay, fantastic. Ignorance of a law is not an excuse. Ignorance of a law is not an excuse. That is what has been categorically mentioned in the passage. Moving on to the next set of questions for the passage. Please read the passage, okay? It deals with void contracts, void due to impossibility of performance. So please read the passage very carefully. Okay. Okay. Are we done? The final slide. This is the final slide, guys, of this particular passage. Okay. The first question of the passage, that is question number 6. Apurva signs a contract with Ashish, who has robbed her of jewelry, to drop all charges against him. Ashish in turn would return all the jewelry. Is this contract enforceable? Now, the correct answer to this question is this contract is void ab initio because it is a crime in the first place. I will drop all the charges against you provided you give me 10 lakh rupees. Suppose a person has committed a crime. Such a contract does not exist in law. Question number 7. Mr. Pandey signs a contract for sale of his BMWs in exchange of 50,000 rupees and 5 kg of cocaine. Very important. After delivery of the car, he receives the cocaine, but not the price. Is the contract enforceable? And the correct answer is no. Is the consideration is illegal. Cocaine, 5 kilo of cocaine, it is illegal. Okay, the correct answer is option C. Moving on to question number 8. Kalpana has alleged rape against her employer. She signs an agreement with the company that if he is acquitted by the district court, she will not appeal to the higher court. If he is acquitted by the district court, he will not appeal to the higher courts. Now, is that contract valid? Now, this contract, it is. Is the contract valid? Please tell me, yes or no? And the correct answer is yes. Appeal is not restricted by Section 28 of the Indian Contract Act. Right? She does not want to appeal. She says that if the district court acquits him, I will not appeal. Fair thought. No problem at all. Right? Question number 9. Ron agrees to pay Harry rupees 1,000 if Dhoni retires in the year 2020 from international cricket. In August, Dhoni announces retirement, but Ron refuses to pay. Can Harry approaches the court for the enforcement of that 1,000 rupees? And the correct answer is no, because it is a wagering agreement. It is a wagering agreement, friends. This kind of betting that if Virat Kohli retires in the year 2023, I will give you 1 lakh rupees. Now, these are all wagering agreements. These are not enforceable under the law. Right? Moving on to question number 10. Rathod makes Rohit sign an agreement for not having sexual intercourse with his daughter, who is 16 years old, prior to marriage for rupees 1 lakh. He also decides that if he is not able to join the armed forces, he will stop seeing his daughter and forfeit his right to ask her hand for marriage. Is the contract valid in its entirety? And the correct answer is contract is valid because it is for a daughter below 16 years. Now, this is restraint of marriage. Is not a valid contract, but exception is a minor. Right? So the correct answer is option B. Am I clear to all of you? The correct answer is option B. Moving on to the next passage. Read the passage very carefully. Okay, moving on to the next slide. See, I'm going through the slides a little fast owing to the fact that you have already gone through these questions. You have already attempted these questions in the mega mock test. This is just an analysis. Okay, are we done? Question number 11 is up there on your screen. Naman enters into an agreement with Devina during an IPL match, which is a wagering agreement. Naman runs out of cash at that time, so he borrows money from his friend Shatwang before the match and tells him that if he is betting on RCB, he assures him that his winning or losing won't decide the repayment of the loan that he has taken from Shatwang. Naman loses the bet and tells Shetwang that because he lost the bet which he has borrowed from Shetwang has gone and cannot be recovered. And the correct answer is, now Naman has to pay back the money that he has taken from as a loan. He has to repay that money. Whether he is using it for wagering agreement or for any other agreement is not the concern. The important thing over here that you have to look is that here is a man who has taken a loan amount to play bet. The betting is illegal, but the loan is legal, so he has to pay that money back. The next question, question number 12. Naman agrees with Devina during an IPL match, which is a wagering agreement. Naman runs out of cash at that time, so he borrows money from his friend Shetwang before the match and tells him that he is betting on the RCB. Hearing this, Shetwang agrees to give him the money and tells him to share the profit. And I will give you the money provided you share the profit that you gain out of the process. Naman wins the bet but refuses to pay that money back to Shetwang. And the correct answer over here is Shetwang cannot claim the money in a court as this agreement is a wagering agreement. Now here we see an agreement which is a wagering agreement. If you win the bet, I will take 50% of the share. So this is what we understand as a pure wagering agreement, which is illegal under the Indian Contract Act of 1872. Moving on. Question number 30. Saif and Kareena works for a production house for 10 years. Saif loves Kriti and wants her to be in the cast of the next movie. Therefore, he tells Kareena to resign from the movie. If she does so, he would pay her 5 lakh of rupees, while Kareena tells that she would pay Saif 5 lakh rupees if she does not resign from the job. Now, what is the correct answer to this question? And the correct answer is, this is not a wagering agreement because the event can be controlled by one of the parties. If one of the parties has a control over the event, then it is not a wagering agreement. Please remember this. One of the parties has control whether the other party gives money or not. So it is not controlled by both the parties, but one party definitely controls the event, the future, right? So, moving on to question number 14. Mahesh and Jeetu are teammates on the IPL sponsored Dream 11. In the process, Mahesh argues that he is better skilled at the process than Jeetu. To prove their claim, they engage themselves in a stake of 2,000 rupees. Now, is this a wagering agreement? Now, is there a skill involved? Now, where skills are involved, very important, where these skills are involved, it is not a wagering agreement. So, the correct answer is, it is not a wagering agreement. Is that clear? Now, these are the kind of demo questions for your preparation for CLAT 2022. So, pay very high attention to these sections which I am discussing with you. Moving on to question number 15. Mr. Arora is a property dealer and insures his house with new Ajanta insurance and pay rupees 50 per month as per the terms of the contract. If the house is destroyed by fire, he will get 50,000 rupees from the insurance company. Now tell me, is this a wagering agreement? This is all which is called as contingent contract, right? So the correct answer is option C. The correct answer is option C. So have I made myself clear? There is a difference between a wagering agreement and a conditional contract. Conditional contracts are legal, whereas wagering agreements are not. Moving on to the next set of passage. For question number 16 to 20, read the passage very carefully. Question number 16 is up there on your screen. The government intends to introduce a truth machine that will be able to detect if someone is lying or not, 100% accuracy. So, is it constitutionally valid? It will not be constitutionally valid because it violates the principle of self-incrimination. You cannot be forced to be a witness against yourself. The doctrine of self-incrimination. You cannot be forced to be a witness against yourself. So the correct answer is option B. Question number 17. Mr. Kumar was seized and taken to the police station as a suspect in a murder investigation. The police officers were well built, with a good voice and demeanor. Fearing that he would be beaten, Mr. Kumar signed a piece of paper stating that he is a murderer, which was later offered as a document for confession. Now, determine if the evidence is question is admissible. The evidence in question, that is the signature as well as the paper which he has said that he is the murderer, is admissible or not. The correct answer is no, it is not admissible. The police officer was well built with the good voice and demeanor. Fearing that he would be beaten, he says that I am the murderer. So this violates your right to self-incrimination. Okay. Okay. Question number 18. Now, a 16-year-old kid was found guilty of rape and sentenced to imprisonment for life. The Juvenile Justice Act was enacted as a result of this ruling. It stated that anyone under the age of 18 would be prosecuted as a juvenile and, if convicted, would be transported to a juvenile home. Now, this boy is trying to claim the benefit of the Juvenile Justice Act. Is it possible? And the correct answer is yes, it is possible. The rule of beneficial interpretation requires benefit to be applied to reduce sentence. So option B is the right answer, friends. Option B happens to be the right answer. Is that clear? Moving on to question number 19. Now, please read and tell me the correct answer. 19. Maharani is accused in the case of theft of Kohinoor, a precious diamond. The punishment of theft when she stole the diamond was 20 lashes. But as the country was moving away from the morality of the law, was amended and the punishment was made 5 years rigorous imprisonment. Now, when he committed the crime, it was 20 lashes. Later on, the law was amended and made to 5 years of rigorous imprisonment. Now, the correct answer to this question is her challenge is justified because the amendment is an ex post facto legislation. The amendment took place after she had committed this particular offense. Question number 20. Sarojini, a cricket player in a Ranji match, assaulted Vijay Shankar and he was selected in World Cup squad and not him, injuring Shankar seriously. Sarojini was arrested by police and prosecuted for the offence of causing grievous hurt. Subsequently, the BCCI banned Sarojini for entire life for playing professional cricket. So from playing professional cricket, here is this person who has been banned. Sarojini challenged this rustication on the ground of Article 20. Now, the correct answer is Sarojini cannot succeed as the ban from professional cricket does not amount to punishment. Only a judge can punish you by a court of law. A court of law's judgment can punish you. Other things, disciplinary proceedings are not that kind of punishment which is envisaged under Article 20 of the Indian Constitution. The next set of passage, please read it. Question number 21. Question number 21. Oja, a pujari, officiated a Napukarba ceremony of one of the children in his locality. Mistaking wine for charanma, Oja drank it in excess, causing her to be extremely intoxicated. He, while doing the havan in his condition, mistook the baby as a log of wood and set her on fire. Can he claim the defense of intoxication? And the correct answer is yes, he can. Because he had no knowledge that what he was doing, because he felt that the child was a log of wood. And he didn't knew that what he was drinking was alcohol. He thought it as a charanamrit, the goddess feet water. Right? If I could explain to you. The next question, question number 22. Tell me after reading, what is the correct answer? Question number 22. Tell me fast. And the correct answer to this particular question. Now, he is a man who has himself drank alcohol. Nobody forced him to have alcohol. Now, please understand this. Nobody forced him to have alcohol. Right? Am I clear? So, the correct answer is option A. Option A is the right answer. Option A happens to be the right answer. Please understand this. Okay. Is that clear? So you guys have already solved these questions in the mock test. It's just how to solve these questions. Okay, I'm just showing you how to solve this. The next question, question number 23. Now, the question is whether this fact deals with voluntary intoxication or involuntary intoxication. Was it given without his knowledge, or was it given with his knowledge? That is the answer. Has Jimmy committed any offense? Has Jimmy committed any offense? Please. The correct answer is Jimmy has not committed any offense, because it's a result of involuntary intoxication. Involuntary intoxication. Have I made myself clear? All of you? Is that clear? This is the answer. Someone mixed his drink with some drug. That's it. Moving on to question number 24. Suppose Jimmy had taken the drug voluntarily, and as a doctor knows the after effect of the drug, will it remain the same? No, the answer will change. Option D. The answer will change. Is that clear? Question number 25. Jimmy is a doctor and is the best surgeon in Mumbai. He saved an actor's life who was injured in an accident. The actor hosted a party where he was recovered, in which Jimmy was also invited. Jimmy is a non-drinker, but the day someone mixed his drink with some drug, after which he became out of control and hit the actor with a wine bottle on his head, which resulted the doctor's death. When he was prosecuted, he took the defense of intoxication. Now, has Jimmy committed any offense? The correct answer is involuntary intoxication. Someone mixed his drink with some drug, after which he became out of control and hit the actor. This is what is the correct answer. He did not ask for drugs. He was involuntarily given. He goes out of control and he kills someone. The next passage. Read the passage very carefully, guys. This particular passage deals with the Jahangir Puri bulldozer demolition of many shops in Delhi. Yeah. I am just running through the slides because you have already read these passages while you attempted for the mock test. Question number 26. What is the correct answer? The right to livelihood has been violated. Farmers were not offered market rate compensations of their land. Farmer disputed this, claiming that the river land are vital for agriculture. They have a right to livelihood, right? Question number 27. Read the question and tell me the correct answer. So the correct answer over here is because they have been imparted with skills that enable them to earn their livelihood adequately. That's the correct answer. So whenever you are reading a passage, implement the meaning of the passage in the question, you will come to the right answer. Okay? Is that clear? Question number 28. The new location where they are transported is an underdeveloped area of the town where they might not get any jobs, right? So if they do not get any jobs out there, how will they live their life? So the correct answer to this question is no, because their right to livelihood has been violated. Okay. Moving on to question number 29. They were not provided with any other places where they could live. The laborers were served with an eviction notice, very well. But they were not provided with an alternative place where they could reside. So the correct answer is option B. Because they cannot be asked to vacate without being provided with alternative shelter, because that violates your Article 21 right. That violates your Article 21 right. Question number 30. The basement where they have been relocated does not have electricity, no windows, no bathrooms. How will the person live? How will the person live? They do not have adequate living condition. They do not have adequate living condition. Am I clear? Okay, before we move on, BYJU'S Exam Prep brings to you a flat 20% discount on your live classes and mock test for CLAT, ALIT, Maharashtra CET. Use the code UNLOCK20 and avail this benefit. BYJU'S Exam Prep brings to you a comprehensive combo course for CLAT 2023. Guys, on 19th of June, we bring to you a detailed exam analysis, expected cutoff, difficulty level, exam pattern, and what is a good attempt at 6 p.m. on our YouTube channel. We also have on 17th, Ask Me Anything by Abhimanyu sir. Moving on to the next set of passage for question number 31 to 35. This relates to the Keshwananda Bharati judgment. Read the passage very carefully. Question number 31. The government announces a rule making the provision for a prayer room mandatory for all government offices. The rule provides that followers of Islam religion may use the prayer room for their namaz. Decide on the validity of this particular rule, and the correct answer is the rule is invalid since it allows an extra treatment to the followers of Islam. Now, you cannot provide some extra thing to a particular religion people. Equality is always there. Then you have to provide a room for every religion people, right? That is not done. Question number 32. Read it and tell me what is the correct answer. Remember one thing, secular means treating all religion equally. Very, very important. Her challenge would not succeed, as the meaning of secularism is not staying away from religion, but to grant equal treatment to all religion. Secularism does not mean that you stay away from any religion. It means equality to all religion. The next question, 33. Okay. Tell me what is the correct answer. Now, The dean has done something which is wrong. The college administration's decision against the secular nature of the country. So the correct answer is option C. It is option C. Very easy. If you have read the passage carefully, it's all good for you to solve the questions. Question number 34. The correct answer is option D. The petition will succeed because you are only allocating land to one religion group people and not to the other. Number one, so it is violative of Article 14, right to equality. Secondly, it is against the secular nature of the constitution. You are favoring one religion and not the other. So that is again against secularism. So the correct answer is both A and B. That is option D. Okay. 35. Delete secularism from the constitution. Can you delete secularism from the constitution? Now, basic structure of the Indian constitution cannot be amended. So the correct answer is the amendment is invalid because it's a basic structure of the country. Secularism happens to be the basic structure of the Indian constitution. Moving on to the final passage dealing with Citizenship Act of 1955. Question number 36. Shamrock is a Tamil refugee from Sri Lanka, and he resides in India. After the Citizenship Amendment Act was passed, he filed a petition. He is a Tamil refugee in Sri Lanka. He files a petition to the Supreme Court with a contention that it violates his fundamental right to equality because Sri Lanka is not added over there. So what is the correct answer? The correct answer is his petition will not succeed as the act demarcating his reasonable classification is not associated with him. India is only, the Citizenship Amendment Act only deals with Pakistan, Afghanistan and Bangladesh and not Sri Lanka. Muskan is a well-known Bardian artist who was strongly influenced by Indian culture and sought to incorporate Indian scenic beauty into his work. He is now seeking Indian citizenship. Now, what is the correct answer? The correct answer is, since Muskan has made sufficient contribution to art, the government can use his power under Section 6 when she makes an application to the government of India asking for an Indian citizenship. The government can do it. It is all within the powers of the government to grant this person citizenship under Section 6 of the Citizenship Act. Question number 38. The government of India is responsible for the upkeep of the historical monuments in India. For Christians, the monuments is also a sacred site. The government introduces legislation requiring all international visitors to pay 500 rupees and overseas citizen of India 350 rupees to visit monuments. Lata, an OCI who is also a Christian who visits a monument on a regular basis, challenges the restriction on the ground that infringes his right to equality, which is guaranteed under Article 15 of the Indian Constitution. Now, the correct answer is Article 15 right is only available for citizens and not for OCI, overseas citizen of India. It is not applicable, Article 15. Okay, keep that in your mind. 39. BYJU'S was born in United Kingdom in 2008 to an Indian mother and an Irish father. BYJU'S application for Indian citizenship is denied because he did not meet the requirements set out under Section 3 of the Indian Citizenship Act. Will he be successful in his appeals in this decision? Yes, since his mother was an Indian citizen and his father was not an illegal migrant during his birth. Very, very important. Mother is Indian, father is not illegal. So Indian citizenship can be made applicable to this person. Have I made myself clear? These are the kind of questions that you will probably be getting in this particular entrance examination. So guys, if you are liking today's session, do share this session, do like this session and make this session, do share it in such a way that every student who is preparing for CLAT 2022, which is coming in the doors ahead, gets a glance through the video. The next question, question number 40. The state approves a new rule prohibiting OCIs from publishing on their social media profile where in India for the duration of their stay. Samit Patel, an OCI visiting India, broke the law by posting something on Twitter. As a result, the OCI registration was revoked and he was forced to leave the country. He appealed the decision, claiming that it infringes on his fundamental right to free speech and expression. Will he be successful? Now, please try to understand the correct answer is option C. Since under the Citizenship Amendment Act, if an OCI card bearer violates any Indian law, his registration may be cancelled. So the correct answer is option C. Is that clear to each and every one of you out there, guys? Okay. So guys, the upcoming session, Quantitative Technique Analysis on 16th at 2 p.m. by Gaurav Gupta. Thank you very much. I hope you understood the analysis that I conducted about the mega mock test that was conducted by BYJU'S Exam Prep. I wish you all the very best. God bless you. Do well. in your on the 19th. May God give all strength to you to crack this entrance examination. God bless you. All the very best, guys. All the very best. Thank you.